go into his lecture since I accidentally deleted the class.
Here's an example of a simple paragraph following the hourglass. All right, welcome to our part 3 lecture on your final.
Come on, stop screwing this up.
Here's an example of a simple paragraph in your week 3. Week 1 was your education with doing research. Week 2 was finishing your research. In week 1, I wanted you to come up with the issues, know the difference between a trial brief and appellate brief, come up with your issues in an appellate issue statement. Week 2, I wanted you to continue your research, finding your bare minimum of 9 authority. Hopefully you found some more. And brief those authority into small little student briefs for yourselves. For week 3, what you're going to be creating is your outline and first draft. If you have been doing what I have been asking you to do since the beginning, your outline is pretty much already done. So you're ready to move right on into your first draft. And what I'm going to help you to hopefully do is to go through the thought process of this to make it, to make it easier so that you can pretty much compile your first draft quite easily. As we talked about before with the hourglass technique, the 3 parts, opening, center, and closing, you don't really need to worry about your opening or your closing until your week 4 polishing week, because those are pretty easy to draft. Your opening section, which is your facts, are basically already drafted by me. That's what happened with Morty. And then your conclusion, pretty much you can draft after you have compiled your conclusion sentences from your 3 mini papers. What you should be focused on for your first draft are those 3 mini papers, as I talked about, those miniature papers. You should be don't be worried. You should be concerned about this week doing your 3 papers on your 3 issues. So you should have, for example, if you chose the Establishment Clause, Equal Protection, and Free Speech for your 3 appellate issues, the topics of your appellate issues, you should have a 2 to 3 page paper on free speech, 2 to 3 page paper on the Establishment Clause, and a 2 to 3 page paper on equal protection. And if you're some of those that were, as I sent out to you all in your part 2, I sent you that law review article because some people were having some issues, difficulties seeing the equal protection argument. If you wish to do some of the subcategories as far as the Establishment Clause, those are available for you as well. A little hint on that is if you're still like, I just don't understand the equal protection argument, think about if you want to break down the Establishment Clause into 2 issues, really, that should have been done. Well, you can do it now. It's perfectly fine. Here's an example of 2 issues that you can argue. 1, a student-led invocation at a high school event, it violates the Establishment Clause. And the court erred when it said that, hey, it can't violate the Establishment Clause. So just the fact that we have a student-led invocation at a high school, that violates the Establishment Clause. Okay? Another issue in itself is the fact the school approving a invocation, and an invocation is a religious message, that violates the Establishment Clause. So that in itself is an issue. The third part, and you all are pretty much aware of this now after doing your research, the third issue is the fact is courts always have to use the Lemon Test, and our court erred in not using the Lemon Test. So those are the 3 sub-issues. If you, at this point, feel that you just don't have a grasp on the equal protection argument for your issues, if you wish to break up the Establishment Clause into 2 other issues, do a free speech and then 2 Establishment Clause issues, feel free to do that as well, too. All right, so moving on to how to compile together this first draft. As I said previously before with the hourglass technique, you're going to be constructing a paper on one of the issues. I'm going to use free speech for the example. I did get some questions from people during the week that they were getting a little confused or a little afraid they were going down the rabbit hole, so to speak, and they were focusing way too much on the facts of the cases that they found. And they said, and somebody asked me, well, what about in this particular case? You know, they did the whole test and everything, but they found that this wasn't a violation, but Morty should be. And I'm like, that's not the point. Remember, we are, and I've said this before, we are not retrying this case. You are not at the trial court level. Your job, you will win if we get this case reversed and remanded. Meaning, if the appellate court says the trial court was wrong and it needs to go back to the trial court for this entire case to be done over again, you have won. And by doing that, we need to look at exactly what the court did that erred, okay? The facts of the cases that you found, the background facts, the actual religious messages or the free speech that was used, that's all fine and dandy, but that's not what you need to focus your arguments on. Now, I have placed for you in this section here, okay, we see the final part 3. I have some thoughts on here as far as what is a rough draft. I have some tips for writing the rough draft. I have, this thing won't let me move it down anymore. Tips for writing the first draft, but I also have what's called the sample paragraph using the hourglass technique. All right. And if you look at this, I'm going to talk about this a little bit. This is an old appellate argument that I gave a while back. And let me just give you the background of what happened. Kim Kardashian, the other Kim Kardashian, had just gotten married, and she and her husband were going on their honeymoon here in the Tampa Bay area, and they decided to rent a boat to have their honeymoon just offshore of Tampa Bay. They were not experienced sailors, but they decided to rent the boat anyway. While they were out on the water, something terrible happened. They called the Coast Guard for help. They did a mayday. Coast Guard said, hey, we'll be out there shortly. It should have taken the Coast Guard 20 minutes to get out there, but it took the Coast Guard 4 hours. Other boats around the area said, hey, we're happy to go help them. And the Coast Guard specifically told them not to go as the Coast Guard was on the way. Once the Coast Guard did arrive 4 hours later, in the process of getting Kim, her husband, and their child off, Kim was seriously injured. Now, at the trial court, the trial court dismissed the case on a motion for summary judgment because it said the United States Coast Guard is offering a service and they can't be sued for trying to be the good guys. In essence, that's what it said. So the Kardashians case was thrown out basically by saying the Coast Guard can't get sued. Well, when doing the case law research, it turns out that the Coast Guard can be sued in certain circumstances. And in one of them is if the Coast Guard makes matters worse, they can be sued because they were negligent in their activities. So with that scenario, here's an example of a simple paragraph following the hourglass technique. And if you look on the second, in the part 2, on the second part of the hourglass technique, I have the paragraph formula and the questions that need to be asked. And if you're looking at that while also looking at the sample paragraph, you'll see that this paragraph answers all of those questions. So let's look at this. So, the court in United States v. Lauter affirmed the lower court's judgment the Coast Guard was liable for negligence in the death of a woman who fell while being hoisted into a helicopter. So in my first sentence right there, I say, here's a case that we found, and here's what happened in the case. In one sentence, I say the facts of the case. The court affirmed the lower judgment that the Coast Guard was liable for the negligent death of a woman who fell while being hoisted into a helicopter. And then I have the full citation at the very end. All right? So in that sentence, I have summed up the entire case. I don't need a whole bunch of sentences. This is where students get bogged down and they fall down the rabbit hole and they give me way too much background information as far as what happened in the case. I need very little background information as far as what happened in the case. Next sentence. The court held, so I said, here's what happened. Now here's the court's ruling, which the court's ruling is the rule of law. The court held that the Coast Guard was obligated not to injure a victim by negligently performing their rescue operations. The spouse of the victim pointed out, and the court agreed, this is the analysis, that this was not a case of omission or failure on the part of the Coast Guard to act, but of a definite and affirmative act causing death, an act deliberately undertaken and negligently performed by its Coast Guard. Through its actions, the Coast Guard not only placed a victim in a worse position than when it took charge, but it negligently caused her death, period. All right. So in that first half of the paragraph, I say, here's a case. Here are some of the facts of the case. Here's the rule of law and the reasoning. All right. So basically right there, I have got a short little brief of the Lauter case. All right. Do you see why in week 2 I had you do short little briefs? Because now you should be able to take your short little brief and make it the first half of a paragraph in your miniature paper. Now in the second half, just like in Lauter, the Coast Guard was obligated. Now I'm talking about our factual scenario with the Kardashians. Just like in Lauter, the Coast Guard was obligated not to injure the Kardashians through their performance of the rescue operations. Although no one was killed in the Kardashians, the Coast Guard not only placed Ms. Kardashian in a worse position than when it took charge, but it negligently caused their injuries. Ms. Kardashian's injuries constitute just a clear example of the Coast Guard affirmatively undertaking a rescue operation and worsening the position's victim through negligence. The court erred, and I'm sorry I can't lower my screen down anymore. The court erred when it failed to consider the negligence of the Coast Guard. Therefore, the trial court erred when it found that the Coast Guard could not be liable for negligence. All right, so as we're looking here, hold on one second. All right, sorry about that. When we're looking here, first half of the paragraph is my brief of the Lauter case. My second half of the paragraph, just like in Lauter, this is now where this is my analysis, okay? I'm not giving a brief of the Lauter case and then saying, hey, we got to follow the Lauter case. I'm giving you a brief of a Lauter case, and then I'm saying why it applies to the facts, or why it applies to the facts of our particular case, in this case, the Kardashians. I have to give that reasoning why. If you can look, I'm actually using some of the exact same language. Up here in the Lauter case, I say, but a definite affirmative act causing death, an act deliberately undertaking, and I look right here, affirmatively undertaking a rescue operation, worsening the position's victim through negligence. This is some of the exact same language, see, negligently performing. Because I want to show that the rule of law in the Lauter case is the same rule of law that I want to use in the Kardashian case, and the court didn't do that. All right? This is what we're trying to show. Here's what happened in a case that I found. I'm not going to spend too much time on it. Here's 4 or 5 sentences of what happened in a case that I found. Here's what happened in our case. See, it's pretty much the same thing. I'm not spending too much time on it. Pretty much the same thing. Here's the same reasoning. We should have used the same reasoning in our case that they used in the Lauter case, but the court didn't. So therefore, the court erred, and it should be sent back, reversed and remanded, sent back to the trial court for them to use the same language over again, or same ruling, or the same process over again. All right? This is the sample paragraph for the hourglass technique. This is how your paragraph should look. Each case that you have should have a paragraph like this. So what you should focus on for this week, take your mini brief and try to convert it into a paragraph that looks just like this. Have your mini brief be the first half of the paragraph, and then create a second half of the paragraph, just like in the case that I found. Morty and the district did this, all right? And you want to say that in the Morty case, we should have followed that particular procedure, but we didn't. Here's why we should have followed it. The court didn't. It should be reversed and remanded back. Really, when it all boils down to it, if you create one paragraph like this for free speech, One paragraph like this for establishment clause, one paragraph like this for equal protection, you should pretty much be able to take the case name out. Like I can right now, in this Kardashian case, I have about 10 cases that are pretty much exactly like the United States v. Lauder case. So for case number 2, I can actually remove United States v. Lauder and put in United States v. McLaughlin, which different case, but almost the same facts, and I literally can keep everything else exactly the same, just changing the name and the citations. And you're going to go, Professor Banks, but that's just repeating yourself over and over again. And yes, it is. Remember, we're not writing, we're not creating, we're not drafting, we're compiling instructions. And when you're compiling instructions, the purpose of legal writing is to convince somebody that you are right. How do you convince somebody that you are right? Repetition. Hey, I found this case and they should have done it this way. We should have done it this way. They didn't. Send it back. Hey, I found another case. They did the exact same thing. We didn't do it again. Therefore, we should send it back. I found a third case. They did the exact same thing. We should have followed it. Send it back. I found a fourth case. They should have done it. Same thing. It's just repeating yourself over and over again. So your miniature paper should have an opening sentence or two stating what your issue is and kind of the logic behind your issue. Then you'll have your 3, if you have 3 cases, 4, if you have 4 cases, paragraphs that are just like this sample paragraph. And then you'll have a conclusion sentence, paragraph, of a sentence or two, restating, it's kind of a rewording of your opening paragraph, but in conclusion form, your conclusion statement, and then you'll have your miniature paper. So if you have an opening paragraph, which is a sentence or two, 3, 4, 5, just depending on how many cases you have, following this sample paragraph, a conclusion paragraph, which is a sentence or two, which is just a rewording of your opening paragraph, there's your mini paper. 2 to 3 pages mini paper. You'll eventually combine those 3 mini papers with a larger opening section and a conclusion section, and then that's your appellate brief. Once again, as I said, this is compiling. So, what you should be focusing on is trying to follow this sample paragraph using the hourglass technique. A little preview into week 4, the polishing and proofing stage. If you notice with the sample hourglass technique, Blue Book citation is very simple. After your first sentence, you have a full cite. Second sentence is an id at the page number. Third sentence is an id. Fourth sentence is an id. And boom, there's your citation. Keeps it very simple. That's why I love this technique. So, what I want you to do for week 3, take those mini briefs, those student briefs that you did. Probably some of you, I looked at some of yours and your briefs are a little long. Try to shorten it a little bit and condense it to something like this so that it takes up half the paragraph, and then create the next half of the paragraph. I will tell you, once you have created one of these paragraphs for one of these cases, you'll find the second, third, fourth, or fifth will be absolutely easy because literally you can just take the case names out and almost repeat yourself. I will warn you once again, anybody with an English literature background or anybody who likes to read or write, this is going to be incredibly painful because it looks like you're plagiarizing yourself and you're repeating yourself over and over again. But that's okay. That's legal writing. Legal writing's boring. You're just trying to convince somebody that you're right. So I hope this helps. If you have any questions, please feel free to contact me. As I've said before, you can email me. Remember I sent you guys my phone number that reaches my cell phone, or you can call my office number, which will forward to my cell phone. Whatever you could, if you need any help on this, I'm just going to tell you, if you're confused, just try doing it. As I said, definitely if you're confused on the equal protection argument, you can break down the establishment argument into sub-issues. That's perfectly fine. If you're confused, just try to do it a little bit. And I think the more you try it and you work on following this hourglass technique paragraph, I think you'll get it. If you're frustrated at the end of it and go, well, I did it, but it seems boring, you're probably on the right track and you have an A paper. So let me just tell you, it's not creative writing. I'm going to have to say this again. It's not creative writing. You are compiling together instructions. So follow this paragraph technique. look at the screenshot that I have of the board for the questions that need to be answered. That's the important thing. If you look at those questions that a paragraph should contain, you'll see that in this paragraph they are all answered, so your paragraph should have the exact same thing. So that's pretty much it. So what I'm looking for week 3, I'm looking for your 3 miniature papers. Once you have submitted your 3 miniature papers, I'll look at them. I'll give you some feedback on them, let you know if you're good or not, and what's going on. I'm keeping an eye on of when people are submitting things. So as soon as you submit part 3, I'll give you some feedback. Hopefully, knock on wood. I'll hopefully get back to you almost immediately with, hey, it looks good, or I would suggest this. I'm not going to rewrite it for you. This is a first draft. I know it's going to be rough. I know there'll be passive voice. I know there'll be fragment sentences and run-ons. The purpose of a rough draft is to just get your thoughts down on paper in some type of order. What I'm looking for this week is this type paragraph. This type paragraph per case. If you get that, you are on track with getting your appellate brief in on time. So as I said, any other questions, please give me a call or email me. Thank you. Take care, guys.
All right. You have this part. That's your outline. You already said that. Let's make this big so it'll be easier to see. See the opening, you see issue 1, 2, and 3 in conclusion on the side. Turn issue into case 1, case 2, broad statement. Done. And number 3. Save these notes. Yeah, I'll save these notes. This is the Kardashian one he's talking about. Save this. Get an idea. So we turn in. Should be good now.